Welcome. We're meeting for our fourth quarterly meeting in 2020 for the Alternative Dispute Resolution Commission. Glad to have anyone who may be observing by virtue of the YouTube streaming. Thank you, John, for setting that up. And likewise, I think we have a quorum, but Steph, would you read off the names of the commissioners to be sure that we have a quorum? Appreciate that.
Yes, Mr. Chairperson. I have Justice Lee as present. Yes. I have Mr. Bridgesmith as present.
Yes.
I have Mr. Cantrell is not here yet. I have Miss Leslie Gaddis as here. I have I have Miss Linda Harris as currently not present. I have Mrs. Herbert as here. I have Mr. Ladd as present. I have Mrs. Reed as here. I have Mr. Rudolph as here.
Present.
I have Mr. Shields as present. I have Mr. Silva as present, and I have currently Mr. Waddy is not present.
Yes, please.
Okay, let's all mute unless we're going to be heard, just for the sake of continuity and volume control. That would be helpful. Also, with the quorum present, want to be sure that we attend to all of the business items that are essential in an appropriate and efficient way. So first of all, welcome Director Tate and Justice Lee. Always pleased when you can join us. And I know that I just saw that Mr. Cantrell joined us as well. So we're even more quorum-ish than we were before. Everybody hopefully has had a chance to look at the attachments and all the materials. Let me first of all introduce, for those of you who have not known that we have interns, one of our interns is able to join us, Shannon Taylor, who is from the Upper Peninsula of Michigan and a director of Community Mediation Center in the UP, and also very involved with the state's online dispute resolution initiatives and also doing training for online dispute resolution. So Shannon, thank you for your cordial offer to assist us in our journey as well. Thanks.
Thank you for having me.
So let's take a look at the minutes. I hope you've had a chance to review them, and if anyone is prepared to move their approval, we'll take that motion. If anyone has any needs for amendments, now's the time to let us know.
I move their approval as presented.
Second?
Second.
Thank you. Any discussion about that? If not, all in favor of approving those minutes, please let us know by saying yes.
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 Thank you. Also, I just see Jack has joined us, so thank you for that. And Linda has joined us. So I think we're virtually a full house today. That's wonderful.
Good.
Next, I want to take a look at the statistics for our third quarter ending in September, July 1st, 2020 through September 30, 2020. Hopefully you've taken a look at those. A little over 1,500 total reported mediations from Rule 31 mediators in that period. The year prior, there were about 1,700. So although not exactly up to snuff for the prior year, it's frankly surprising to me that as many mediations as were reported in fact occurred in light of our very difficult time over the summer with COVID and remote everything. So it's encouraging to see that not only are the reports continuing to come in, and we know never as full as they need to be, but nonetheless, the effect and the issues resolved and the fee types are pretty consistent from year to year percentage-wise, even though this is about 200 less than the year before. So the next item on the agenda is the issue of, let's see, our next quarterly meeting. So please put these on your calendars. if you are going to be with us, we'll talk about those who are not in a moment, but January 19th, April 20th, July 20th, and October 19 next year. Same time, 10:30 a.m. Central. Just be sure you get those on your calendars. And we are sad to say goodbye to some of our colleagues who will be going off the commission, effective that first time in January. And we want to say thank you so much to Linda. And let me also repeat what we've heard so many times, Linda, that this most recent seminar, our conference of last week, was extremely well received. So congratulations to you and your training committee for doing that for us. Also, Ed Silva is leaving us, Celeste Herbert is leaving us, and Jack Waddy is leaving us. So you are all stalwarts and have been a part of really fantastic growth of the influence of the ADRC, and we deeply appreciate your participation. And Ed, especially your participation as chair has been remarkably valued by all of us, and we can't thank you enough. Don't know if we have any of our new commissioners coming that will be watching in any other capacity through the YouTube, but we also are pleased to welcome the new commissioners who will be joining us. And they are Charles or Chuck Hill, Sarah Fiegel, Betsy Meadows, and Cindy Ettenhoff. Cindy is from Memphis, works closely with Steve in a number of initiatives there. Betsy is from Knoxville and works closely with Celeste. I think they're in the same firm, so we have the continued influence of Celeste through Betsy. Sarah, as you probably all know, is here in Nashville and is the director of the Nashville Conflict Resolution Center. And Charles does an enormous amount of work in education and ombuds work as well as mediation. So we're really getting some stars as well who are joining us. So the last item on the agenda for my remarks has to do with the response to the court's backlogs. And if you can bring up those slides, I think you're running them, are you not, John? Just so you know, as a result of the apparent sense that courts might be having backlog issues, we wanted to survey the judges across the state to see, one, if that was true and in what arenas those problems were arising, as well as their willingness and desire for mediation assistance. So, John, do you have those or should I present them? I can do it either way, whichever you prefer.
Sure, you may have to present them if you have them handy.
Okay,
I missed that part.
Yeah, that's okay. Let me pull them up. Because the, well, hold on. Don't know why they're not coming up on my machine. You must be cursed. The long and short of it, let me just give you, they're in your materials, you can see them. But we talked about this with Justice Lee at the conference last week, but there are about 400 sitting judges and we surveyed all of them. We got, as you can see now, 179 responses. And the question was, are you experiencing a backlog? So the next slide will show that yes, close to 60% are experiencing a backlog due to COVID-19. And the next slide will show you the same thing in terms of percentages. The next slide is asking them, are you willing to consider mediation as a method to help address them? And half of those who responded, and remember, the people responding included judges who are not experiencing a backlog. So virtually, almost the same number of judges experiencing backlogs are willing to consider mediation, which is really hopeful and promising. The next slide will show the Wisconsin survey, and we won't go through that, but Wisconsin did a similar survey in the same basic time frame. And you can check those slides to just see the relative success that mediation has taken in Wisconsin and the court's receptiveness to mediation. So there's another document in your attachments, and it was a proposal that was floated by the Supreme Court, and it was pulled together with the assistance of the Community Mediation Center directors statewide, as well as TAPM and the great work that the Tennessee Association of Professional Mediators. And the questions asked were of the court, how would you like us to assist, if at all? And so we've done items 1 and 2, because we now have the names of judges that are interested in using procedures in the mediation arena. And the question for us as a commission is, how do we want to respond? So we can address that either in an ad hoc way by the creation of a subcommittee. We can refer this to the CMC groups that are across the state and have already indicated their willingness to assist. But I just wanted to bring you up to speed on the fact that the court is supportive of this, the Supreme Court. Justice Lee has pled our case for us, and we have permission to implement any and all of this proposal. So we'll come back to that, because this is sort of a new item on the agenda. There is no structured way for us to deal with this at the moment, but we will deal with it by the end of our meeting today. So that's my report. I'm going to turn it over to John to give the program manager's report.
Thank you, Larry. I'll get these slides up here, but I'll just kind of walk through them and talk through them. And if anyone has any questions, please interrupt me. First, I'd like to close out a progress report on ADRC action from July. The commission requested and approved that we give 5 tuition-free spots at the annual seminar for each of the 6 CMCs. We did that. A few did not turn them in, but I believe over 25 participants were tuition-free from CMCs. We requested that we list CMC info on the AOC website, and I have it up here and the link if you'd like to visit it. The information was provided by the CMCs. It was voted that we give special acknowledgement in the newsletter and a 1-pager in the new mediator packets, and both have been done, and we'll continue to do that for upcoming newsletters. And the commission also voted to approve a pilot hybrid training program. I'm just showing you where it's located on the website, the link, and to let you know that it'll be covered later, I'm sure, but we do have some approvals since July. We had the Alternative Dispute Resolution Institute, Belmont School of Business, Lipscomb University, and Private Dispute Resolution Services. And we have one more in the queue for review by the committee. This is all in your material. If someone has questions about it. My next quick topic is that mediator renewal season is open. Mediators may renew on the portal. It's all digital as we transition to last year. This will be our second go. This is a live shot of how someone logs in and then clicks on their renew my listing in the bottom right-hand corner. Once they've submitted a renewal, which takes about 3 to 5 minutes, once they submitted it, this is what they see. You have a renewal application pending, and you have a check mark as well. And that's to let you know when you have enough CMEs in order to renew, the 6 hours that are required every 2 years. Next, I wanted to update you that access and visitation for 2020 and 2021 combined, the federal FY have been awarded, and we're working on contracts to get those folks up and running. We have 8 new organizations joining, and we're going to have a kickoff meeting next Tuesday. The total amount was $179,500 spread across the state You can see many different judicial districts represented in many different organizations across the 3 grant divisions. And then just to update you quickly that we've reported in the past that funding was a hurdle for our Hamilton County Medical Debt ODR pilot, and we're glad to report that we've been awarded a technical assistance grant. There's a link if you'd like to know more about these types of grants. We've been awarded the first $15,000 with the additional balance to be awarded when funding is made available. And then since then, we've been working on the scope of work with our organization providing the software, that's Court Innovations, and negotiations over contract. And last week we had a meeting with our provider, Erlanger Hospitals, as well. So we're keeping that moving. And that is my report, sir, pending any questions. I didn't hear any, but I'll pause for technical issues.
Yeah, any questions with respect to that? Well, I
Well,
think
hey,
we
Larry,
can,
John?
please, go ahead.
You know, who gives the grant? What's his technical assistance? Is that state money, federal money?
The State Justice Institute grant, is that what you're referring to?
Yeah, the technical assistance, is that state money, federal money? I'm just curious.
Yeah, it's not either. It's the State Justice Institute is an independent foundation established to assist the administration of justice in the states. Our director has really close contacts with folks there, and we put together a proposal which was awarded at the end of August. And it's a grant in the total amount of $50,000 for the purpose of working out the pilot program on online dispute resolution. It's our hope that we can not only apply that to the Hamilton County medical debt issue, but that we can find even more applications that we could perhaps develop over time, especially things like the upcoming crisis that has yet to really be realized with respect to evictions post-COVID. And as you may or may not know, the CDC has a moratorium on eviction processes that is in place until the end of the year. And at that point, who knows what the result will be, but the evictions of tenants within leaseholds across the state is going to fall very hard on those who can least afford it. So we hope to be able to provide an ODR pilot there. And Steve, you and Cindy and Shelby Counter are sort of leading the league there. Hopefully we can deploy it in your neck of the woods after we've launched the medical debt pilot here in Hamilton County. Does that help? Does that address your question, Steve?
Yes, it does. Thank you. Thank you very much.
Yeah, sure. Yep. Anything else, John, or questions for John? Let me just say on behalf of all of us, John, the work that you and Steph and Louise and the entire team were so essential for our conference to work as well as it did last week. And we just can't thank you enough for the great assistance you all provide us in so many areas. So we wouldn't be able to do anything without you. Thank you.
You're welcome. We enjoyed the pivot and the opportunity to use technology to engage and communicate with our mediators. And it was a full court press and effort. So thank you.
And did you supply to the commission the evaluation slides that I saw for the first time earlier today? Has that been provided to the commission as well? John?
No, sir. I did not share them with the full commission. I have them ready. We can do them now or during training and education.
Well, I just want to be sure they have them, and we can talk about them more particularly when we get to training. If you could go ahead, if that's possible, and share them with the whole commission, that would be valuable.
I'll work on that.
So let's begin the committee reports. And Celeste, this is your last report. So you all have done such a phenomenal job in managing credentials. We will miss you, but please give us an update on the work that needs to be done now.
Well, I echo your remarks, Larry, on the great work that the staff does, because it makes our job as committee chairs much easier to have the support, information gathering, and follow up that Steph and John and the AOC staff does to support us in these roles. One topic I want to take up before we get into talking about individual mediator applications. The Credentials Committee wanted to have a discussion with the entire commission with regard to the topic of whether someone is unsuitable for the practice of mediation. And let me sort of frame that discussion by telling you that some professionals have disciplinary actions, some of them in the past, some of them in the near past. Some of those disciplinary actions have resulted in private and public discipline. And so we've been wrestling with the issue of how do we apply this standard of unsuitability for the practice of mediation with regard to the issues of discipline by professionals, not just lawyers, but any professional. Jack, have I stated that pretty succinctly from our committee discussion?
Jack, if you're talking, you're on mute.
Pardon?
You were on mute there. Now you're not. Go ahead.
Okay. I absolutely echo that. And the fact is that committee work would be awful without the help. I don't know if we'd get it done. We certainly wouldn't enjoy it. I'll say that. You probably would have had some resignations.
But what I was trying to get at, Jack, is the discussion that we had with regard to unsuitability for the practice of mediation. And I know you had specific thoughts about that.
Well, I don't remember the specific guy, but I just remember there were just a number of things that pointed to me that this person was not what I call a good lawyer. I mean, the way he conducted his practice, I mean, the things that were missed and the things that were not done, and that doesn't strike me as very suitable to do what we do. I wouldn't want to put that kind of a person out there before the public and say we have approved this person as being a competent person, because I think that there's a lot of evidence that they're not. I mean, when we get those kinds of things, it's easy to rubber stamp and say, okay, I can't put my hand on something really, really specific. But there's a time in the lawyering world when, as a lawyer, you get a feel for what's right and what's wrong. And this particular instance I thought was wrong. And it's a general concept that when we're talking about suitability for this practice, it shouldn't be that we're having to look around a lot of stuff. That's my view.
I would be interested in hearing from someone like Ed, that has had a long history with the commission, because maybe historically there's been a discussion about this at some point that I wasn't privy to, and the other members of our committee might not have been privy to.
It's kind of like wrestling an alligator. in the sense that we always struggled on what does it mean to be suitable for the practice or unsuitable. Clearly, if there is a defined disciplinary proceeding and one has been found to violate whatever rules of conduct were applicable, that's an easy one. What Jack is wandering off in, and what we've talked about in the past is just character issues, I think, Jack. Isn't that what you're talking about?
You're breaking up on me, Ed. If you're talking to me, I think when it's black and white, that's easy. I mean, just rule on black and white. I mean, right now we're talking about something that would demonstrate an unsuitability for the practice of mediation. Well, I mean, this one that we reviewed last week, or where it was written all over that. I mean, you couldn't pinpoint something that violated a specific bar association code of conduct, but that's not what we're limited to.
Well, Larry, this is Steve. If I could try
Yes,
my
sir.
hand at
Please.
it, is, you know, we're making professional judgments. And so the question is, what guides our mind? It's like our own standards, okay? They guide our judgment. And so the first question I've got is, well, if they're unsuitable for the practice of mediation, what is suitable for the practice of mediation? And so now I turn to our rules and I take a look at the appendix section 2. And Jack, this links in with exactly something you just said, is that the general standards say in section 2 that to be qualified as a neutral, you have to have integrity, impartiality, and professional competence. And so the first thing is, if somebody's handled their law practice in an incompetent way, then that's a red flag for me. If somebody has stolen money, then that suggests that there's an integrity problem, as well as some of the other issues. So I guess what would guide my mind to a certain extent, and obviously this is not precise, but at least there's something here to guide my mind in terms of, is this someone that possesses the integrity, the impartiality, and professional competence, or are they unsuitable to those qualifications? I looked up the word suitability and it says unsuitability, it says unfit. David, those are just sort of general comments, Celeste.
I think that's really helpful, Steve. You know, the balancing act is, if someone is still licensed to practice law, does that in and of itself, or licensed to practice whatever profession that they're in, does that in and of itself qualify them to become a mediator? And none of the issues that we've been wrestling with involve people that have had any kind of disbarment or some sort of action to revoke their professional license.
Well, as I said, I think that you have the situation where you got black and white. They've violated code of professional conduct. They've been reprimanded by the bar. Those are pretty easy. I mean, but we have a standard of suitability, which I think involves some discretion. And to me, that does not include people who fail, who miss deadlines, who refuse to act on cases that have been entrusted to them. I mean, this person we were looking at before, I mean, he had to be, I think, reprimanded because he or she, because they had an estate that they didn't close out. They missed they had a statute of limitation problem. I mean, we got plenty of competent people. Why are we interested in adding incompetent people in this profession?
The problem is the subjective standard versus the objective standard of what's suitable and unsuitable. And the commission's always struggled with that, Jack, and hopefully the marketplace takes care of a lot of those issues just by reputation before someone gets a referral, the referring attorney or the referring court understands, I think, who the competent ones are, who are, quote, not suitable. But unless we have an objective standard and a finding of that, then we're all going to just base it on what we think is the right thing, which is not the right thing to do, in my opinion.
Well, Ed, since you raised the question of objective standard, what does an objective standard look like to you? Do you have any ideas what objective? Go ahead.
If you've been reprimanded by your organization, rather than a private censure, but a public censure, something that is of record of past behavior or conduct or professionalism. Other than that, we're just getting into whether we like that person or not.
So
I respectfully disagree, and I'm rolling off of this thing. I can shut up and move on, but I respectfully disagree because what you say is that he's been reprimanded by his professional organization. Those are clearly instances that within our rules are established as making someone unsuitable. But this standard that we've got is activity that would demonstrate the unsuitability of the practice of mediation. Well, why do we have that language if there isn't some discretion within the commission to deal with it? Because if otherwise we just say if he's been reprimanded, he or she's been reprimanded if they're lawyers, they've been reprimanded by the bar, they're not suitable. That's the end of it. If they're a professional psychiatrist or family, I don't know, social workers.
Therapist?
So
Yeah,
can I have a comment, please? I would.
Sure.
So when you're talking about objective standards versus subjective standards, it's got to be across the board. So if we want to say, if Jack, if you want to take that position, it has to be if you have 4 disciplinary actions, even if they're not resolved, then that's objective. But when you get into this individual is not good, but this individual is, that becomes subjective. And I would be concerned about whether or not this commission in approving people would be considered a part of, quote, state action. And whether the state then is preventing someone from engaging in a profession because in his, quote, subjective opinion, I've got 5, this person has 4, unless we have across the board standards, we may be, I think the commission, like you, I'm not going to be on it, but I think you may be opening up a can of worms.
I don't care. I mean, I live in a can of worms. I mean, that's my world. I live in a can of worms. I deal with it. And I don't deal just with the easy things and take, please understand this with all due respect, but I think there is a higher standard that we should hold ourselves to, which is dealing with these kinds of problems and not putting people out there as Rule 31 approved mediators that are unsuitable for the practice of mediation. Now, I don't get to make that determination, but there's 3 or 5 people on a committee that do that. And if 5 people, the majority of a 3-person panel or a 5-person panel, or we present it to the whole board or commission, thinks that person is not suitable for the practice of mediation, and we ought to act that way. And I don't think you put a number that says 4 reprimands versus 3. There's certain things where there's actual specific things that have happened that you can identify, but it's got to be something. I mean, look, I'll pass. I've made my argument. I've said my piece. I think if this commission wants to let people in as mediators, Rule 31 mediators, who have failed to follow through on a closing estates, who have missed deadlines, who have done that, probably the tip of the iceberg, really showing the incompetence and inattention to detail of the practice of law. I don't think they're qualified, but that's me.
Mr. Lester, yeah, Frank, please go ahead.
Actually, this is Rick Ladd.
Okay. And then Frank. Go ahead, Rick.
Okay. Oh, go ahead, Frank. I didn't want to
No,
interrupt
go
you.
ahead, Rick.
All
You're
right.
fine. Go ahead, Rick.
I just want to point out, as I'm hearing Jack, he wants to expand the unsuitability beyond disciplinary history in some instances. And we don't have the authority to do that right now, because if you look at the provision that's up on the screen, it says the applicant must not have a disciplinary history with the board or agency charged with issuing license, et cetera, that would demonstrate an unsuitability. So I think the way this is currently written, we are limited to board disciplinary history to determine whether or not somebody is suitable or unsuitable. To expand that, the unsuitable, suitable finding outside of official or formal discipline, I think would require a rewriting of the rule. And I agree with Jack. I think there are some instances where we should maintain our discretion to say no to someone who has, for whatever reason, avoided BOPR sanctions or other professional regulating bodies, but enough information has been presented that they're just not suitable. In other words, I don't think that unsuitable should be limited to disciplinary history. Now, Steve mentioned the general standards and qualifications, and if you read them, I think you can easily interpret those to reflect a neutral exercising their duties post-approval by our committee. I don't know that you could apply those particular standards pre-approval, even though it does use the word qualifications in the title. Thank you.
Thank you, Rick. Frank, go ahead. I'm not hearing you. Are you on mute? I see your mouth move, but I hear no sound. Still all quiet on the Frank front.
Sir, he's unmuted on our side as far as Zoom. So
Yeah, I see that.
They need to reconnect or come back to him.
Do you have a mute on your headset that maybe also needs to be off? Now we're going high tech. This will get us there, I'm sure. While he's getting connected, I was hoping that we could get Frank into the conversation as the scrivener and the master of words. So how about it? Are you there with us, Frank, yet? It's better. Can you turn up the volume?
One moment. How's that?
It's better. Everybody hear Frank okay?
I've got a little closer to my mouth now.
Good.
Okay, sorry about that. I just wanted to mention a couple things. One, this is a new provision from the rewrite of the rule. The way that the rule formerly read, it was that the person had to be of good moral character as evidenced by 2 references accompanying the application. And we included, we left the 2 character references as a requirement, but then we also added the requirement that they disclose criminal convictions, et cetera, and then added all this language that we're talking about here today. And I agree with Rick and Jack to the extent that what we currently have does give the committee discretion to use their judgment, and I've got perfect confidence in them to do that. Now, it's within the context of the disciplinary history, but I don't know that I would want to personally go beyond that. I think that if a person doesn't have a disciplinary history with their board or agency, then I think we reach the point where it's too subjective, because then we start dealing with things that just came over the transom, as they say. So I'm comfortable with the rule as it is, but I'm also comfortable that it gives the committee discretion that they should not be hesitant to use.
In that regard, just looking at the language, it doesn't say a disciplinary history with adverse outcomes or findings. It just simply says a disciplinary history. And again, the choice before us, it seems to me, is do we have an elastic definition that has no room for judgment, or do we have to come up with a very precise list of disqualifying criteria? So that's the question before us. Celeste, did you have any input on that as well?
No, I really don't. You know, when the committee was meeting, we were trying to think about things in terms of, was the incident recent? Was the, or did it occur 10 years ago? You know, those were all sort of factors that were floating around that we were considering. And I mean, I think this is a healthy discussion, and hopefully it will continue to guide the committee as it acts in the future with regard to applications and approval of mediators. I'm like Jack, I'm going to be rotating off, so it's not going to be something I'm going to be dealing with.
Just one more thing, Larry, if I could. I think, Celeste, I think you're right on the money, and I can't help but think of how we do it in the rules of evidence. When we look at whether a criminal conviction is admissible, what do we look at? Well, number one, was it serious enough? In other words, was it a felony? Number two, was it recent enough? And number three, even if it wasn't those two things, did it involve dishonesty, et cetera? And I think that's a pretty good system. I don't know that I want to adopt it in chapter and verse, but certainly if I were looking at it, I wouldn't be able to help but think about it in those terms.
One other voice from the committee that we haven't heard from. Lori, do you have anything to add to that conversation? Lori Reed, are you with us still? We see you, but we don't hear you, Lori. Could you unmute for us?
Yes, I am so sorry. I am on the phone preparing for a mediation tomorrow. So ironically, during our commission meeting, one of the things that I wanted to add was, if it hasn't been already addressed, we asked people to, or the staff asked people to explain some of their disciplinary actions, and some of them were extremely helpful and just really, you know, gave us what we needed. And some of them just dismissed it like, it's not a big deal. I'm not telling you what happened. And we felt like that was a sign of someone that, you know, wanted to really be a mediator or didn't. I don't know if that's been addressed yet, Celeste. I didn't want to say something duplicative.
No, it hasn't been addressed, and that's a really good point, Lori, because you know, I think you're absolutely right that some people are very forthcoming, and then others have chosen not to give an explanation that was requested.
Larry, I got one last comment.
Please.
That the words must mean something, otherwise they wouldn't be there. It must be applicable to some sort of behavior. I agree with sort of Frank's framework, but I didn't realize, were these words then added during the amendment process? Then those words then were added to fill some sort of gap, I guess. And I don't know what gap it filled.
I think it's the very gap we're talking. Yeah, I think it's the very gap we're talking about. I think that the way the rule read before, if I'm remembering correctly, if you could come with two references of your good character, then that was as far as we could go. And the group that was working on the rule thought that the committee should have just the kind of discretion that we're here talking about. and that's where we landed.
So,
So I guess go ahead.
so the only last comment I have is that I heard a couple of things that I thought were very good, and that was a framework and an opportunity to be heard. I think that occupations are considered property or liberty interest. So I think as long as the commission has a framework and an opportunity to be heard, you do have that discretion, but it just needs to be consistent, I think, and have a objective criteria.
Okay, any other comments or questions before the commission about this topic? So what action do you want us to take, Celeste? Do you want us to?
I don't know that we really need to take any action per se. And I think Frank's giving us the sort of the legislative history, if you will, is very helpful. I just think that this discussion is going to be helpful to the committee members as they move forward on applications.
Are you satisfied that that's all that's necessary, or do you want more action on the part of the commission at this point?
I don't really know that there needs to be any kind of a motion, because I think that we've had a discussion about the unsuitability for the practice of mediation, and that discussion is that we're going to try to apply some objectivity, but I think that Frank's comments highlight the fact that the intent was to give some discretion, and that discretion, as Linda pointed out, needs to be exercised wisely and consistently.
And I think that's a really good summary of what I'm hearing. Anybody feel differently about the outcome of this conversation?
The only thing that I would like to ask, Larry, is I suggest that if anybody, if the board itself or anybody on our commission feels that there is no discretionary right in the committee that handles these credential committee representatives, somebody needs to speak up and make a motion, because if the board wants to say that the committee is limited to actual disciplinary action by the controlling authority, then say so and make it a part of the rules. And that way there's no question when the committee's meeting, you move on. There is, there isn't, we move on. If everybody's acceptable with the fact that there is some discretion in the committee, we don't have to do a darn thing, because we can have just a general statement that the commission affirms that the committee has discretion in determining suitability, and leave it at that. And then if there are problems, the committee can come back to the board and get guidance. But if the board thinks there's no discretion, then you need to pass a resolution to that effect. That'll make it real simple for everybody working on that committee.
Does anyone? Yeah, go ahead, Jack.
No, that's all.
Anyone feel that is required, or do we feel like the explanation of the intent of the drafters is sufficient to recognize that discretion with careful consideration to consistency, as Linda suggests? Hearing nothing, I will take that as we now have had the discussion you wanted. Celeste, are you satisfied that it addresses your concerns?
Yes, and I think it'll be very helpful moving forward, and John and Steph can, use this discussion as a frame of reference for the new committee members, and hopefully some of you all that are presently on the commission will be members of the new credentials committee when it constitutes in January. I think we can move on to the mediator applications. There were 33 on the batch list. 26 are recommended for approval without any kind of further discussion. I guess we need a motion to approve those.
I'll entertain that motion.
I'll
Someone
move
move to approve.
I'll move to approve the 26 applicants.
And I'll
Second.
second that motion.
Thank you, Leslie. Any discussion? All in favor, please say aye.
Aye.
Opposed? No. Okay, that is passed.
There were several other persons who applied that the committee and staff worked through some issues on. I don't know if we want to discuss these individually or not, but there are several of them that after we went through the information provided and supplemental information, that we move them for approval as well.
And you're talking about A, B, C, D, E on your list of applications, correct?
Correct.
Any questions that anyone has with respect to any of those particular individuals or issues? If not, can
If
we
not,
have
I'm
a
gonna-
motion?
I'm
Yes,
going to
go
move
ahead.
for approval of Mr. Becker, Mr. Duggar, Mr. Morente, and Ms. Patterson. And I may have missed, I don't know if I missed one or not. That's
I think that's all of the approval recommendation.
Second.
Thank you. Any discussion? Hearing none, all in favor of approving those new mediators signify by saying aye.
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 Opposed, no. That passes. Okay, go ahead.
Steph, could you explain Ms. Robinson for us?
Sure, I'd be happy to. There's certain information that I am not allowed to say. She had a law license first issued in 1990. She is active and in good standing. This is her, I guess, issue here is regarding disciplinary history. We asked her to supply a letter of explanation regarding her disciplinary history. She did reply, but did not give a lot of detail in regards to those various complaints. And the committee had decided after their discussion to recommend deferral until she supplied a better response to AOC staff.
And Ms. Brake, this is John Jefferson. Ms. Brake is exactly correct, spot on. And we are following this.
John, are you speaking to us or is it your background?
Yes, if you can hear me. Ms. Brake is correct in all things. We can take the guidance that was provided today and try to attempt to apply it in our next meeting. But we did recommend deferral.
And I think perhaps the same applies with Ms. Suttle, that we recommend deferral based upon the fact that we were going to have the discussion that we were today. So perhaps it would be appropriate to just make a motion to defer the applications of Rebecca Robinson and Chantel Suttle pending further follow-up and discussion among the Credentials Committee members.
I'll make the motion so we can get into the question. I so move.
Second.
Thank you, Celeste. Any discussion?
Yes. So I don't know that I have enough information, quite frankly, to make a decision, because there's something about Ms. Robinson and there's something about Ms. Subtle. But if you're asking for a vote, then I'll abstain, because I don't know. I don't know what so we're being asked to defer something, and I just don't feel like I've got enough information. I don't know why.
Ms.
Well-
Harris and the rest of the committee, I'm sorry if I didn't set you up for success. So you have individual packets and information that is not available because we're streaming and in the public trying to follow Tennessee DPR's confidentiality guidance. So
Ms. Harris, it would have been provided in the credentials and the materials I submitted yesterday via email.
Okay, I
you'll
see
be
it
able to
now.
review that.
I do. I see it.
Yes, ma'am.
Attachments number 9 and 10 in your packet.
Okay.
I had understood you to move for deferral. Did I misunderstand you, Linda?
So that's what is that what we're moving for, right? Deferral?
Correct.
Yes.
Okay.
And Celeste had seconded that, and that was the motion on the table. So any additional conversation about that motion to defer these until further information is received? All in favor of deferral, signify
Aye.
by saying aye.
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 Any opposed to deferral, signify by saying no. Motion passes. Thank you, Celeste. A great conversation and great insights. Appreciate all the hard work.
Mr. Chairman,
So
this
Linda.
is Rick Ladd. May I ask
Yes, sir.
a question, please?
Certainly.
I'm going to note something, then I'm going to ask a question out of pure ignorance, but I went through the Credentials Committee recommendations, and I found it interesting that there are 6 people who have over 5 complaints with I think they're all with the BOPR. 5 out of the 6 are requesting certification as a family or domestic violence mediator, and 1 to be listed as a general civil mediator. I am on the hearing board for the BOPR. I don't know that we have ever had a family law case come before us, a contested hearing. But my question is, for those that practice family law, I've got anecdotal evidence that you're more likely to be reported to the bar if you practice family law than you are if you practice general civil law. And I just want to know, is that correct?
That's certainly been my experience, Rick. Others want to respond to that?
That's my understanding as well. That situation is one that unfortunately, sometimes even both parties are dissatisfied with the results, and it's easy to blame your lawyer rather than, taking any kind of self-responsibility. So yes, I think that's a given in that field. And, there were a number of these applicants where an investigation basically just proved that the complaint was not valid.
Okay. Well, that's interesting. That's sort of what I thought, but I didn't have any information to back up that thought. But that appears, and maybe we're already doing it, but that appears to be yet another consideration when we're looking at somebody who's applied to become a Rule 31 mediator, is what is their general practice? In what practice areas do they practice law? And if it's family law, it sounds to me like we've got to give that some weight with multiple Board of Professional Responsibility complaints. And again, we may already be doing that, but I'd never made that comparison before.
The Credentials Committee is doing that.
Okay.
And that's certainly something that we've discussed, and especially in the situations where we've requested additional information, it's become very evident that the complainant was basically dissatisfied with the result versus the attorney's work itself.
That's half my client. That's all I have. Thank you.
So be careful, Rick. All righty, thank you. Any more conversation about credentialing and recommendations? All right, let's move to the Training and Education Committee. Linda, this is your last report, so knock it out of the park.
Okay. So I'll try to be quick. The first thing we have is the training waiver requirement for Tiffany Schaefer, is number 11, the attachment. She has applied for family listing. Her credentials definitely met the qualification of substantially, the substantial equivalent to the training for domestic violence. She had quite a bit of training, and I hope everyone has had an opportunity to look at her materials, and our committee recommends that approval for both the family and the domestic violence waivers. I think the Credentials Committee already voted on her.
So you're recommending approval for the waiver request and training. Is there a motion?
Yes.
I so move.
Thank you, Jack. A second?
A second.
Thank you. Any discussion? Hearing none, all in favor, please say aye.
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 Opposed, no. The motion passes. Thank you for that. So this is your opportunity to really shine, Linda. Give us some reflections.
Well,
on the
before I give
18th
those
annual
reflections,
ADRC book.
I want to
I'm sorry?
just say how honored I have been to serve on the ADRC Commission. I really have been around some of the best mediators, the most knowledgeable mediators, and the most respected mediators. And to be able to call you colleagues, I have truly been honored. I also want to thank everyone for participating in the workshop. Justice Lee and Larry, thank you for kicking us off. Steve and Jack, thank you so much for the value that you all brought to the presentation. We got some very good feedback, right? The ADRC feedback and CLE, it was sent out this morning, and I just think that it's been the best yet. I honestly believe that the 2.65% who said that they strongly disagreed, they actually meant that they did. They just, like I did at first, I hit the wrong one and I figured it out. That's my belief, and I'm sticking with it. So overwhelmingly, people strongly agreed that we did a great job with this, and we got a lot of positive comments. Do you want me to go through each one, John?
Either way, you could. I was just going to scroll through them slowly.
Okay, you want to go through them? Go right ahead. Are you going to go through them?
Many of you folks took this exact survey, and this is about.
John, we're not hearing you well. You're breaking up on us.
That's okay. Go ahead, Linda. I'm sorry. I'll scroll through them. You go ahead, please.
Okay, so the substance rating, of course, we had more than 65% to say strongly. Right, there we go. Strongly good. Okay, the attention, the attention rating, the presentation held their attention. If you go to the next one, I can see more clearly what the number was. Okay, we had 60% who strongly agreed, 42% who agreed, and you can see the rest of it. There were 114 people. On the technology rating, I was able to easily access, view, and participate in the program. 85% strongly agreed. 19% agreed. That was pretty good out of 113. That was great, actually. The course materials were helpful. If you go, okay. We had 61 that strongly agreed, 41% I'm sorry, 41 people and 61 people out of 113 either agreed or strongly agreed. That was great. We had a large number of the attendees were dual. Yeah, large number were dual. There were 60 with dual listing, and 34 was our next largest category. The listing status, dual, okay.
I think that's it, Linda. You've been great.
Yeah.
Sorry about that. Continue.
Okay, 42 dual and general civil 30, 97 people in all that responded, right, John?
That's right. That's pretty representative. That's fairly representative of the total pool of 150.
Okay.
But not all have responded yet.
All right, so you can see we had 30 general civil and 42 dual, family listed 23. Those were our large categories, and 2 other.
Very good. Thank you, Linda. One last item on your agenda, and that is the hybrid pilot training program. You want to speak to that?
Yeah, John mentioned it. We had the Alternative Dispute Resolution Institute, the Belmont School of Business at Lipscomb University, and Private Dispute Resolution Services have all been approved. And that's as it relates to A. And then as to B, that's going to take just a little bit of discussion. That's attachment number 12. We received.
I don't have the.
You don't have attachment 12? Okay, there it is. So the committee voted to bring this to the attention of the full commission because we received this request, or it's more of a comment.
Hey, Melissa, will you come here real quick?
From Laura Metcalf.
Go put that in my office because it's can't turn it down.
Leslie, can you please unmute, please? Okay, go ahead, Linda.
Laura Metcalf is a trainer, and she trains in family law, and she raises the question about what. So the commission so far has said you can only do 16 hours online training. And she lists 3 different categories of individuals and seeks to, at least at a minimum, make an exception for these 3 categories. And those 3 categories are those who have maybe subject to COVID exposure, those who have pre-existing conditions that prevent them from being in person in light of COVID, and those who are required because of COVID to supervise their children's virtual learning. They cannot do 30 hours of in-person training. So we're bringing it back. I mean, I know we're at 16. If I have any final recommendation to this committee, it would be that you consider doing more of the training online and maybe even get to the point where you flip, there'd be a 16-hour, for example, requirement of training for in-person and 30 hours online. I think that our workshop this year demonstrated that online training can be successful. And I think that it is just a matter of time before it's going to be 100% online. But 16 hours of in-person training, and those 16 hours could be dedicated solely to scenarios. That's just my opinion and my recommendation that the commission will ultimately approve that at a minimum. But
Linda, Larry.
Yes, please, Steve.
Tell me if I'm out of order here, but I would like to go ahead and have a discussion, and I would like to make a motion to revise the application to provide not just 16 hours, but all 40 hours and all 46 hours up to as a pilot program through our April 20th meeting. I think that Linda's made some great comments about what our online training was. All of the training at the University of Memphis School of Law, I spoke to every one of the clinic directors yesterday. All of the clinics are being taught virtually. All of their hearings are occurring virtually. I understand that there's training at Belmont, at the University of Tennessee. And I think as long as we have this COVID-19, I think that we should go ahead and simply approve the 40 hours or the 46 as a pilot program through April 20th. And as you can tell, although my first 16 hours were merely the informational part, I was surprised, although I limited it to 6 students, that there was a good deal of interaction among those 6. So I don't know if I'm out of order or if this is somewhat later, but I would like to make a motion at the appropriate time, Larry.
Okay, let's, this is what was just recommended by the training committee, or at least that topic was recommended. So obviously it's on the agenda for us to discuss. And as another trainer educator, I have been living in the world of virtual training for about, I guess, 9 years. I work at the Arizona State University School of Law, and that is a hybrid online training in law school level negotiations and mediation. And my experiences are, and surprisingly, the students' experiences are, that they are surprised to find that the simulations done online are as effective in their view as if they were done face to face. And as an educator, I would also say that nationwide, educational institutions, although forced to move into remote learning with COVID, are now providing significant support for its acceptability. It's not to say that it is the same as, you can't simply convert an on-site training to an effective online training. And there are plenty of indications that doing online training well can be equal to or superior to doing it face-to-face. So that's my experience, and there's a lot of data, a lot of anecdotal evidence to that effect. So I'm just passing that experience on. Other comments from others on the commission?
I move that we vote on whether to make the training available for make the full family and civil mediation as well as domestic violence mediation under the pilot program up until April online completely.
Okay. Motion, do we have a second?
Second.
Thank you, Marcus. Any further discussion?
Frank? I want to discuss it, Larry. I've been opposed to this from the beginning. I think you can train and teach substantive issues. You can teach the statute of limitation. You can teach the rules necessary to get a preliminary injunction. You can do all that stuff online and do it well. I don't believe that you can do it effectively in teaching people the negotiating and nuances of interaction in the same way. And I think we should shy away from this. I think that this is one of those situations where it's convenient. It's not good. And y'all can disagree with me. It may be convenient is all get out, train, a bunch of people with online training on the nuances of mediation. I don't think it's as good. I don't think it's what we ought to be doing. I don't think we should support it. And I'm totally against it being a full 40 or 48 hours of training online. I think we're going to have less qualified people put into the public cycle now to do that. That's my story.
And you understand that the motion on the floor is just for a pilot for a period of time until April. It's not a permanent suggestion, right?
And I don't think we need that pilot because look, I'll step aside. I mean, y'all, you do it like you want to. If you think that's going to help us, I mean, what's the reason for doing it? It's establish something that I don't think you can establish other than just override practicality. So I'll withdraw.
Yeah, I'm going to turn it over to Frank, who had a comment. Go ahead, Frank.
I think that, first of all, I do not oppose the idea of having it all online. My observation so far has been that I have just not been comfortable that we have approached this issue with the level of technical knowledge that people should have. And Larry, I think you probably have that knowledge, and I think others on this commission may also have that knowledge, but I would feel much more comfortable if the folks who are approving this training would consult with some experts, whether it's at Arizona State, whether it's the University of Memphis, whether it's at Belmont, and find out what are they doing to require that the level of online training meets the need for them to be able to say that this student got the appropriate education, and that we adopt that. I feel like any attempt that I make to simulate that is just me searching around trying to use words I don't really understand.
Appreciate that.
Larry, can I make one other comment, Larry? I gave a presentation, was it Friday, for half an hour on mediating with the difficult participant. Half an hour. There was not a single question to ask of me. There was not a moment of dialogue. And I think we had the capacity to do it. And I guarantee you, if I'd have made that presentation in person to 120 people, I'd have been bombarded with questions. And we'd had a lively discussion, and we would have learned things, and we would have played, we would have done roles, and we would have done all that. I mean, it doesn't work the same. And we've tried it as a trial mediation, and it'll be in my rearview mirror when y'all decide on whether to make it permanent. But I urge the board to be discretionary, the commission to be more discretionary about what you're doing here, because if you start and take a practical look at what would happen if you went to total virtual training, you would eliminate that dialogue, which I think is what happened with my presentation, happened with most of the presentations. Anyway, that's my point.
Yeah, we heard it. We've heard it repeatedly, and we thank you, Jack. It's a perspective that is relevant and worth listening to. Other comments or questions from anybody on the committee? We have a motion before the commission to provide on a temporary basis between now and April until our next meeting, a pilot to explore the benefits, the downsides, the effect, and how best to, if possible, provide online training exclusively. And it's in light of the COVID crisis and the unlikelihood that any face-to-face engagement in the near term will occur. So comments related to that, if anyone else has them, please.
Well, Larry, I would simply indicate that community mediation centers do need to train people. They are concerned about meeting face-to-face. And, you know, Jack, when this came up the first time, I thought the gap between face-to-face and online was significant. I've narrowed that gap now that I have done a good deal of this. And again, every University of Memphis School of Law course, I don't have the detail that Frank wants, but I spoke with the Director Katie Ramsey Mason, the Clinical Director for Medical Legal. I talked to Donna Harkness for the Director for the Elder Clinic and Danny Shafton, the overall. And they have all told me, and maybe this isn't the detail that you want, Frank, but they have simply taken their traditional training and done it online. Obviously, they probably made some adjustments. And they have told me, and I should just tell me straight up, that they said it has been effective. And they've been effective in translating that into the representation. And I think that we need to do that as a pilot program to also give us feedback in the specific context of training mediators. And I would support the motion to have online training up through including April 20th.
The only concern I have is I'm sort of like Jack, and maybe it's because we're both old, in that I don't think there is any substitute for in-person looking somebody in the eye education, whether it's on mediation or whether it's on some other subject. I have a real concern that these kids that are going to law school right now are not getting the kind of education that's going to serve them well in a profession that they hope to practice for the rest of their lives. I hope I'm wrong, but I know from my own personal experience, I don't pay attention as closely when information is delivered through a computer as I do when I absorb that information live. I think that, you know, as a pilot, that this is a good idea, but my fear is that this is going to translate into something that we're going to just say, you know what, we can do all that in the future. Look at what we've done, and it's going to revolutionize education as we know it.
Mr. Bridgesmith, would you
Yes, ma'am.
have a problem if I made a comment?
Please.
So a couple of things. So I was actually in Mr. Bridgesmith's negotiation class. And as far as the quality of the education and the things I learned in that class, the way he ran it, the checks and balances, the knowledge, the role plays, you know, I thought were fairly effective. Again, it's, you know, there is a difference in between doing this face to face compared to online. But I mean, I got, you know, a very similar experience when I took my 40-hour general civil here in Michigan. You know, and currently within Michigan, we just revised our training standards to be able to accommodate online training as well. And, you know, we've had a lot of the very similar discussions. We've launched a couple different trainings online and had some of our more nationally renowned trainers in the state do the trainings and come back with the feedback, you know, and it does take, you know, a little bit of practice. But we're learning the ropes and we're working the kinks out, and it's actually turning out to be quite effective. One of the first things that we did clearly was we decreased the number of participants that, you know, the trainings and that we're able to hold. But, you know, I mean, and again, I think if, you know, you could create trainings that were similar to how Mr. Bridgesmith teaches his, you know, online negotiation class, I don't see any reason why they wouldn't be successful whatsoever.
So this is Linda. I call for the vote on this.
That was not a paid. Yeah. Okay. We have a motion before the commission to run a pilot program between now and our next meeting in April of 2021 to provide an opportunity to develop and deliver training on a trial basis entirely online. That motion for the commission. Say again? I'm not hearing if somebody's wanting to speak. I'm not hearing.
Not me. This is Ed.
Yeah, please.
Can you hear me?
Very spotty, Ed. It just comes and goes.
My concern is the difference between having a retail program and a wholesale program. And there's a reason why the costs are different, because in retail, you get more for what you're having to pay marginally. And I'm just really concerned about a training that is virtual from start to finish. I just think you're going to lose that part of the training, which is integral to making a better mediator, which is that person-to-person contact, instruction, et cetera. I just personally am opposed to having a virtual training from start to finish. I just can't see how that's going to make a good product at the end of that process.
Okay, the question has been called, so we'll put it to a vote. All in favor of the motion signify by saying aye.
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 All opposed, say no.
No.
Larry, can I
hear
suggest
two- I hear one no.
can I suggest by chat?
Go ahead.
If we could, since there are people opposed, maybe we could do vote by chat or
Roll call.
roll call.
Okay.
Okay.
Let's do a roll call. That'll be faster and people might not know how to chat. So Stephanie, can you do a roll call? And as chair, I will not be voting, so you can't count my vote either way.
Yes,
And
sir, be
Larry,
happy to.
would you restate the motion? It's to approve a 100% virtual training up through April. Is that the motion?
Yes. As a pilot program.
Okay, we can go on with the roll call.
Yes, Mr. Chairman, I'm ready. Can everybody hear me all right?
Yes.
Excellent. Okay. I'm going to go ahead with the roll call for this motion. Mr. Cantrell, what is your vote?
Yes.
Mrs. Gaddis, what is your vote?
Yes.
Mrs. Harris?
Yes.
Mrs. Herbert?
Yes.
Mr. Ladd?
A qualified yes. I would be voting no were it not for the pandemic. So yes.
I got it. Mrs. Reed?
No.
Mr. Rudolph?
Yes.
Mr. Shields?
Yes.
Mr. Silva?
No.
And Mr. Waddy?
No.
Mr. Chairman, I have 7 yeses and 3 nos.
Steph, I hear your report of the yeses carry. I think Mr. Bridgesmith is frozen for just a moment. I'm going to ask
that's what happened to you.
Yeah, so I'm going to ask as PM a point of clarification for Ms. Harris and the Training and Education Committee, and if anyone has any concerns as well. First, Steph, can you hear me clearly?
No.
We can a little bit, maybe if you turn up the volume a little bit.
Okay, I'll do my best. So I just want to let folks know that we're going to use the same requirements and the same guidelines in our pilot program and then application that apply, and just change it to all virtual is allowed. It still must be synchronous, and that is done at the same time.
Can't hear you, John.
Yeah, John, try to get closer to the mic.
Or maybe you want to call in, John. You might have a better audio.
But I believe what he's trying to say is the other requirements in the pilot program are not going to change. They should still be synchronous, I believe is what John was trying to say.
Yeah.
My motion is only to revise those 2 paragraphs to keep the virtual application as is, but revising it to include, though, the right to have all online training in paragraph, whatever it is, John.
And I'm just referring to the prior policy as well, because anyone who seeks to do that has to satisfy the training committee that their preferred delivery will meet the needs of the rule. So there has to be an application and a review and an approval of those credits. Is that correct?
That was my motion, only to change the 16 and whatever to 40 hours. All of the other requirements would remain the same.
Okay, thank you. Well,
there-
that motion passes. We will, go ahead, please.
This is Lori Reed. Would there be a way to require that the applicants participate in a full, at least one or two full remote mediations before they could successfully complete the all online training?
Isn't that a part of the current requirements? Steve, you've got them before you.
Yeah, provide the detail regarding the trainer's familiarity with the delivery platform, provide a link to recording segment, provide detail regarding the trainer's experience in mediating online and delivering training online. And so I think implicit, if not expressed then, that somebody should have participated in virtual mediations.
I think that would be very helpful.
Okay. Just looking at the clock, we have 30 minutes. Is there any further discussion on this particular topic? Okay, let's move forward.
That's going to conclude my report. I do want to say thank you to John and Stephanie also on the workshop. Thank you for all of your hard work and the entire team.
It was a lot of fun this year, that's for sure.
And sleepless nights, but thank you. No report from the Pro Bono Mediation Advisory Committee. Is that right, Steve?
I gave a summary of it in my attachment. In the printed material, it says attachment number 13. That's forth. It's pretty straightforward.
Yeah, the agenda on the screen is not the most current.
Okay, thank you. John, can you tell us about the grievance committee work for the last period of time?
Mr. Chair, can you hear me?
Very well.
Oh, thank you. So grievance committee, yes. I'm sorry, do you want me to go back to show anything, or did we close that pro bono mediation out?
We did. We've closed it out.
Thank you. Sure. Just as it says on the screen, 3 mediator complaints were closed since our last meeting following Rule 31, Section 11. I'll say that 2 were dismissed throughout the process for no violation found, and 1, the mediator was not a Rule 31 listed mediator, and we helped the complainant find the right process. And that's all, sir.
Thank you. No action required by the commission?
No, I thank each of the grievance committee members for the sacrifice of their time.
And that's a thankless task. So for those of you who serve, and you serve because you've been chosen to do so, we try to keep that geographically representative, but are not always able to do so that we have some from each of the grand divisions serving on each disciplinary review. But again, thank you for your excellent work. Ms. Gaddis, do you want to provide a communications committee update?
Yes, so we worked and had published a newsletter during this last quarter, and we actually sort of tried to go with the times of COVID and publish something that was time appropriate, considering what all our struggles in trying to practice law and frankly trying to mediate during this time. So we had a mediator in Memphis, Beth Yarbrough, do an article about mediating via Zoom and the benefits of it. And I think we've had, I certainly will defer to John too about this, but I've certainly had a lot of very good feedback about that article. I think everybody trying to figure out how to put a positive spin on our requirements to do so many of these things by virtual. And frankly, it's interesting. I have found myself, I'd be curious to know from other members of the commission, it actually, there are lots of things that make mediating by Zoom even better than face to face. And so I thought her article was great. I'm hopeful that all of you were able to read it, because I think frankly, I learned a lot about mediating via Zoom when serving as a mediator. So that's the main thing that we did in our communications for this past quarter. I can't think of anything else. If anybody else on the committee can think of anything, but that was really our main goal. And we certainly succeeded at getting something out that we thought was certainly a current issue that we could help, mediate Rule 31 mediators with.
Yeah, thank you for your work, and that communication function is vital to our community out there. So thank you for keeping the entire statewide community of mediators up to speed. Frank, Ethics Advisory Committee, you have a specific matter. It's in the materials at attachment 13. Is that correct?
Yes, sir. And I'm ready to talk about that. Larry appointed a committee to address a inquiry that we had received from a Rule 31 listed mediator. And as Larry mentioned, it's attachment 13 in your materials. The big picture question was that a court refers pro se cases to a community mediation center for mediation between the parties. And upon an inquiry from the mediation center about how to do reporting and remote filings, etc., one judge responded, please send a copy of the signed settlement agreement for our file. Upon receipt of this signed agreement, the court will either dismiss the case or continue the case, whichever is appropriate. So the question was, pursuant to Rule 31, could a Rule 31 mediator supply a copy of the signed agreement to the court under Rule 31? And there were 3 related questions submitted. And again, in a nutshell, what the committee determined was that if a Rule 31 mediator provides or files a mediated settlement agreement with a court, that is a violation of Rule 31, Section 5, because Section 5 talks about what the final report shall contain, and it talks about it in exclusive terms, and those terms do not include a copy of the signed agreement. The second question was, what would happen if the court ordered the mediator to do that? And once again, the committee was of the opinion that given the specific limitations in Rule 31, Section 5, that the general provisions in Rule 31 that deal with orders of the court would have to give way to those specific provisions. So once again, that would be a violation. And then third, the question was, well, what if the parties agree to have the mediator file the report? And similar to question 2, the committee was of the opinion that the parties could not agree to allow the mediator to violate Rule 31, Section 5. So the opinion is that a Rule 31 mediator is not permitted to provide a copy of the signed settlement agreement to the court. And as I discussed with our chair, under Rule 31, it's actually the prerogative of the committee to issue this report. But because this report was completed so close in time to the meeting, we just thought that it was best to let the commission take a look at this in its draft form before the committee makes the decision to send it out.
This is obviously a tough one, and it's not a new one in terms of Rule 31. Rick and Leslie, did you all have anything to add to that conversation as members of this committee?
Well, I'm not, it doesn't sound like I'm interrupting Leslie. What I saw was a key point to this is the judge is requesting too much information to do what he or she needs to do. And the purpose of requesting the information was to determine, as I understand it, whether the court will dismiss the case or continue the case. And to me, all a judge needs to know is, was that case resolved in mediation, yes or no? So again, I think the opinion accomplishes both requirements, one, Rule 31, and I do think that with a mediation report that is allowed by Rule 31, the judge is going to know exactly how to proceed in that particular case.
Leslie, anything to add? Are you with us, Leslie? Are you still taking care of mediation prep? We understand it if you are and can't comment, but love to hear from you if you're able to. Okay, yeah. Any other commentary?
Yeah, Larry,
this isn't this.
Yeah.
Yeah, go ahead, Steve.
Obviously, I've had conversations with other executive directors of community mediation centers. And so I realized that the way this was framed, maybe it needed to be framed differently. I don't know if the outcome for the committee will be any differently, but I'd like to use the word Frank used. And that is that it's not the mediator who is filing this, it's the mediator who is supplying this. The mediator's the mailman. Is that there is no filing. The parties are the ones that are filing it. The parties the judge is asking to file it on behalf of the parties, or the parties themselves are saying, will you please file this for me? And I know in at least one mediation center, those individuals may be 20 or 30 miles away. They're doing it virtually, and they may or may not know how to complete and file something. And so maybe this simply requires, I don't know, some other discussion or some change in the rule. But I think that the way it was framed is, I think it's framed better by what Frank said, and that is simply to supply, not file. And I don't know if that makes a difference or not, but it's kind of like, you know, the mediators being the mailman. I assume if somebody was in my office, maybe I take this too far and said, will you go put this on your fax machine and send it? I'm kind of like the mailman. And in any event, and I can't speak for the court, why the court wanted, I mean, I've got an idea, obviously. They wanted to know where to dismiss it or to continue it, to have it in the file. But in any event, I simply present to you a different frame, if that would make a difference in the outcome, if that framing of saying it was being filed, if it's reframed as simply saying it's being supplied, if that would make any difference in the committee's mind.
Larry, this is Frank, and I don't speak for anyone but myself, but I don't think that would make a difference in my mind. The example that you give of the mailman, I think doesn't go far enough. In that example, the person who's attempting to get this document somewhere the idea has originated with them, that wouldn't it be more convenient, since I'm standing here and I have an envelope with a stamp on it and I see your mailbox over there, wouldn't it be more convenient if we just dropped it in your mailbox? I don't think that's what's happening here. I think the idea is originating with everybody except the parties. And so to me, it makes no difference. I don't think that it's a question of the technicality of filing versus supplying. I think it's a question, as Rick says, of and there's a natural, and we all know it who have practiced trial law, there's a natural division between what the fact finder should know about negotiations and what the fact finder shouldn't know. And it's not because the fact finder will misuse the information. It's because the settlement process works better when the parties are assured that what they're free to say and do what they want, because the fact finder won't be apprised. I'm sure 99% of judges would handle the information just fine, but that's not the question in my mind. The question is that the rule obviously recognizes that in this one and only instance, there is an express limitation on what you can provide. And I just feel like we're following that express limitation.
And I would remind the commission that if this advisory opinion is not satisfactory, then the parties who raise the question can always request a reconsideration. They can appeal it to the whole commission. This isn't the final stage. This is simply for information to the commission. And frankly, we don't have to approve this advisory opinion. It is the work of a single committee. And if someone is dissatisfied, there are steps that they can take to clarify or seek further instruction. Is that your understanding, Frank?
That is my understanding. And at the same time, though, I'm very interested in what people have to say about it. And I know that Rick and Leslie feel the same. That particular reframing just didn't move my needle, but it might move theirs, and they may contact me after this meeting and they may say, hey, Frank, we need to take a second look at this.
Well, we will leave that to the committee to decide, and if they decide to issue it as is, then that's your decision. If you choose to revise it in any way, that's your decision as well. It was just really for information purposes. Let's see where we are. Okay, nothing for you, Ed? I'm sorry?
Yes, you're there, sir, Rule and Policy Committee, and then I have two clarifying statements, if I may, before business is concluded. Over.
Okay, go ahead.
Yes, sir. So that we can apply in the PM staff, apply the action taken today. There was a few technical difficulties, so I have two questions / statements. So for the trainers that have already been approved for this hybrid pilot, these new conditions apply to them, kind of grandfathered in. They do not need to reapply. Is that no issue with that statement?
Well, I heard that if the revision to the application process does not affect their application, then yes. If there is any revision to the application process that you followed, then they would have to comply with that. But
okay,
that's what I heard. Anybody else have any insights on that question? Okay, your other item?
That's right. Thank you. Number two, the 12-person restriction that we voted on in July continues for the virtual portion. That was the commission's concern, 12-person for the virtual portion. And we're going to leave the in-person, how someone conducts the in-person portion, up to the trainer. They're going to follow the COVID protocols and the local restrictions and how they do that with buildings and rooms. But that's not something that we're getting into. We could care about the 12-person virtual. Over.
The 12-hour or 12-person?
There's a 12-person restriction that we put on the application, and in the approved 12-person restriction. When a organization wants to have 13 in person or 14 in person, we're not going to get into that. That is allowed. That is permitted.
Well, you have a specific request. Is that not correct, John? Can you tell us about that?
Yes, we have, and we have a trainer who, trying to comply with all of our with ADRC approval in July, is having to push folks who got interrupted by COVID. And so they would like to have a 13th person in the room during the required in-person. And it's kind of moot, but it still is not with the action taken today. So I just want to make sure no one has any concerns about a 13th or a 14th being added.
I'm confused, Larry. If it's virtual, if the trainer is conducting the 40-hour virtual, the limit is 12.
Yes, Steve, and we'll continue that.
If you're telling me that there is a trainer who is saying that they're going to do it all physically present, or they're going to do a hybrid, the question is, does the 12 limit apply to those two formats? Have I got it?
The in-person, the in-person hours. Yes, as we approved in July.
I think the specifics are not general because there is a specific question being posed by Lipscomb with respect to, well, actually it's a student who was unable to participate in the September in-person event who wants to attend as the 13th person in an upcoming in-person training at Lipscomb. Isn't that what prompts this question? John?
It does. Applying the commission's guidance to that scenario.
So I guess the question to the commission is, can the committee make an exception under specific circumstances such as that to the number of participants? Otherwise, the 12 number stays the same, I'm assuming.
Larry, this is Frank. I'm still confused about this person. Are we saying this person took some part of the training in person and now just wants to complete it in person and wants to
Correct.
be the 13th person in the room during the personal portion of a hybrid training?
Frank, this is John. I can confirm that's correct.
Okay. I mean, I'm like Steve, or I think on this one. When you're in person, there's not a 12 limit.
Thank you, sir.
I mean, that's me. That's just me personally.
That has certainly been the case. If they were able to conduct an in-person training, there has been no restriction in terms of the numbers of people, even under the pilot, which was just limited to this hybrid exception. So does that satisfy?
Thank you, the
John?
chair. Thank you to the chair for the time. I'm sorry if that was confusing. We want to apply it equitably across the board as the commission desires. Thank you.
No, thank you. One final piece of new business, which was where we started in my first remarks before we move to adjourn, and that is there a sense on the part of the commission as how best to respond to the judges who have indicated their desire for mediation assistance in view of their backlogs, according to the survey that we shared with you? I put it out to the commission. Is this something that you want to create an ad hoc committee to deal with in the near term? Is this something you would like to refer back to the CMCs and to tap them to work on? The point is that there are at least half of the sitting judges in the state who have asked for assistance from the ADRC for mediation to help address their backlogs. So what is the commission's sentiment in that regard?
Well, Larry, this is Steve. I suppose maybe one approach is this. We have an advisory committee made up of, in all likelihood, most of the help is going to come from the community mediation centers. And so what if we turned it back to the advisory committee to work on this in collaboration with TAPM? They all know each other, obviously, probably most of the same people. And so that we simply turn it to them and have the advisory committee then report back to the commission. Would that work?
Are you prepared to serve as that liaison? And it's really just continuing your role as the pro bono mediation advisory committee.
Oh, I get it. Okay,
liaison.
sure. Sure.
Okay. Well, and to Steve's point, that's where the proposal came from. The CMCs and TAPM work together to create that specific proposal that you have in your materials. So Steve's suggestion, if you want to make it in the way of a motion, is to simply turn it back to those individuals and those entities to address and come up with an approach to satisfy the judge's request for help with respect to their backlogs.
Yeah, I move that the advisory committee in collaboration with TAPM come up with an approach to satisfy the judge's request for assistance in mediation.
Do I have a second?
I second that.
Thank you. Discussion. Hearing none, I think, unless somebody is seeking to be heard. Hearing nothing in discussion, I ask for a vote. All in favor, please signify by saying aye.
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 If opposed, no. Motion carries, and Steve, your job continues. Thank you for your willingness. Just so you know, in the closing of our time together, look at us. We have 4 minutes to spare. I'm going to give you back 4 full minutes. The next Rule 31 application deadline is December 1. Again, thank you to the serving commissioners who will be leaving us. We appreciate very much your hard work. And,
Larry, could I just say thank you to everybody that I've met. I've enjoyed meeting the people. I've made new colleagues and friends. A lot of very bright people, very capable people, and I appreciate this time that I've spent with you. Staff has done a great job. Ed, you did a great job of chairing this commission. Larry, you've done a good job. Same with Howard Vogel. And so it's been a good ride, but I'm glad I'm getting off the
saddle. I'll second that, Jack.
All in favor? Aye. Well, thank you all, and appreciate the hard work you all do and the work that you do on behalf of mediation in this state. I'll take a motion to adjourn. Second?
Second.
All in favor? Aye.
Aye.
Go have lunch. Thank you all.